Hey there, this is Pat Ennis of Ennis Legacy Partners. Welcome to the Exit Readiness podcast. I'm here with co-host Walter Dial, who is the tax partner at GRF CPAs and Advisors, and here in Bethesda, Maryland. Our mission here on the podcast is to provide you, the business owner, with subject matter expertise on topics pertaining to building transferable or sellable business value, and then planning for your eventual exit from the business. We want to help you build a business that's sellable and then exit on your own terms and conditions. If you are a regular listener to the podcast, you may have heard us at some point say something along the lines of business owners cannot do exit planning without doing estate planning, and they cannot do estate planning without doing exit planning. And so Walter, of course, we've said that over and over and over, probably painfully at this point, but what are some of the, in your practice this past year or so, what are some of the common estate problems or issues that you're noticing or observing in your practice?
Well, I think number one, and you see this all the time too, is you ask someone who their estate planning attorney is, or what estate planning they've done, and the answer is they don't have an estate planning attorney and they haven't done any planning. This is one of those topics, and Micah obviously is very aware of this, that a lot of people just don't like to deal with. And I think now with the exclusion being so high, a lot of times people think, well, estate planning doesn't really matter anymore, but they forget the fact that it's not just about estate taxes. It's about, how your assets are going to be handled after you pass away. And if you're a business owner, the last thing you want to do is not have prepared for this, because you're dumping all this on the lap of your survivors. It can be a total nightmare for them. And if you're a business, it has to be carefully coordinated with your business planning, your succession planning, all that, because it's all very interwoven.
Yep, exactly right. And although I think you would agree, both of you, most business owners leave or exit their businesses in life and move on to the next chapter, many indeed do exit their business with an unexpected or premature death. And so a key planning issue for the family, for their family if they have one, and or business partner if they have one or more of those, at that point, is the transfer of ownership of the business interest. And too often, as you just said, Walter, it's a planning issue that's neglected and overlooked. And so it's a core exit planning issue that we feel it's wise to just review and remind listeners of regularly, even to over communicate it, if you will, because it's so critical and so essential. So that's our topic today, estate planning for business owners. And we have with us again, attorney Micah Bonaviri from Stein Sperling here in Rockville, Maryland. Micah's been with us at least once or twice. And on Stein Sperling's website, it says this about Micah. With his relaxed, engaging nature, Micah Bonaviri has a natural ability to make his clients feel comfortable with trust and estate planning, often being an emotional and complex topic. Micah recognizes that for many clients, the underlying concern is for their loved ones, financial and general well-being. He seeks to put his clients at ease by actively listening to their goals, enabling Micah to develop creative estate plans in a clear and efficient manner. I have found all of that absolutely to be true with Micah and working with any client that we've referred to him for estate planning or buy-sell agreements or whatever we refer them to him for. And so, Micah, welcome back, particularly on a day when you're getting ready to leave for a golf trip to West Palm Beach, Florida. We're excited to have you back, and thanks for taking the time.
Yeah, no, thank you, Pat and Walter, for inviting me and having me participate again. It's great to be here. Great to see both of you, and appreciate the kind words and look forward to providing some thoughts and considerations here as we discuss, the coordination of estate planning and exit planning.
Yeah, and of course, you heard the opening comments and just our commitment to regularly, continually, even over communicating this planning issue, and so here we are again doing it today. And let's just open it up for where do you think we should start this conversation, Micah?
So I think as a sort of beginning matter, it's really important for everyone to recognize when there is a business involved, when a client does own a business, yes, it's obviously an asset that is owned by the client, and possibly other business owners, partners, other members, whatever it may be. But that type of asset is different than all of the others. So there's more consideration, there's greater detail, greater thought that needs to go into, well, what happens if I become incapacitated or if I pass away with the business interests, which is a little different than what you may want to happen with, say, proceeds in a bank account or a brokerage account, or what you may want to happen to your home if you become incapacitated or pass away. So I think that's sort of like the beginning issue to really wrap your head around, because it's often one of the more valuable pieces or assets in someone's estate or in their trust. And it's something that has a lot more considerations than just what happens to it. I think from a big picture, if you own this business and if you're able to successfully sell it and exit or transfer it while you're alive and have capacity, that's great. That's the goal. That's the hope of everyone. And I know that you guys do a terrific job of helping walk them through all of that. Where we sort of come in is, okay, yes, that's still the goal, but what happens if we don't quite get there? So what happens if while you are considering this and walking through and formulating this succession plan and trying to facilitate it, you become incapacitated or you pass away? That's really the difference in what we need to plan for and why it's so important that it be coordinated with your estate planning documents. Because oftentimes it's not as easy as saying, okay, when I pass away, I want my business to go to my spouse or to my kids, right? There's way more things that we need to think about. Who would be running the business? What if your spouse, your children, your partner, whoever wants to sell? Who can they sell it to? Where does the money come if they want to buy your interest out? What if you want to keep it within the family, but you want to transfer voting rights to someone else? There's all of these different things that, you need to sort of think about beyond just who receives it when it's sold, who gets the money, things like that.
Yeah, exactly. So, and as you know, those are the things that we begin to help them think through, and they've thought through it prior to coming. We bring them to you, and you help them think through it even more from a legal perspective and get the legal documentation in place that needs to be in place. And it is much more complex. It's much, and you've mentioned a lot of the different things that need to be considered there. It's much more complex than, let's say, transferring a commercial real estate building or a residential property. It's a complex asset, and as you said too, oftentimes it's the most valued, and the family may need that business to continue in order to provide financially for the family. And if the business cannot continue, because all those factors that there are even more factors that need to be considered and planned for aren't put in place, the business may not continue, or it may need to be sold at deep discounted fire sale prices, and so that could put the family into a dire financial situation. When you are presented a new client and their business owner, and they don't have it, maybe they have in place an estate, what an estate plan. What are some of the overlooked pieces or neglected pieces of an estate plan that you might see that maybe hasn't been looked at in years?
Yeah, I think, right off the bat, the biggest thing is that everything is just sort of lumped in together, right? So at some point they did a plan, and the plan just says, let's just use an example. When I pass away, everything goes to my spouse if I'm married. And then when my spouse passes away, or if I survive my spouse when I pass away, everything would go to my kids, right? So that's a very common plan for a married couple with children, right? And that works for lots of the assets, right? Let's say that the children are young or, still sort of not mature enough to be in charge of the inheritance themselves. We would have their assets, whatever they would be receiving, go into a trust for their benefit. Maybe we have someone else as trustee, an aunt, an uncle, a family friend, whoever it may be. And then when the child gets older, they may be able to become their own trustee or access the inheritance some more. But the problem is, sort of going back to what we talked about, is when it comes to a business, that's very different. And so you can't lump the business in with all of your other assets. So if someone has a will, or even if they set up a revocable trust, it's not something that you just probate or that you just transfer into the trust and not think about anymore. Because as we sort of touched upon, what if, for example, what if one of them is involved in the business and the other one isn't, right? If we distribute 50% of the business to each of these trusts for your kids, or even to them outright, does voting power and economics go with the child that's not involved? Or, do we want to separate that and maybe have all voting stick with one child, the one that's involved in the business, and have non-voting interests go to the other child? Things like that, where it's not sort of a 50-50 split, if you will, like you might do with life insurance money or a bank account, or the sale proceeds of a home. So that's often one of the biggest ones, is identifying who's involved in the business, who do we want running the business in the future if, we still own it and we still want to operate it. Lots of people will say, well, I'll take the business, I'll put it into my trust, and my trust says, if I become incapacitated or pass away, my spouse is in charge of everything, or whoever it may be. Well, that may work for lots of your other assets. You got joint bank accounts, you got retirement money, you got, brokerage accounts, whatever it may be. But maybe for the business, you might want someone else to be operating it, right? And have your family receive the economic benefits of it. But maybe your family members might not be the right people to actually continue the business. So that's something that can be addressed in your documents. And again, it's not just lumping it together with the other assets, it's sort of carving it out and saying, okay, I do want my wife or my family or whoever to be in charge of these assets and direct what happens to them and be in control of them and the investments. But the business, maybe I have a key employee that I'd like to give more of the managerial role to, still have the economics, right? And the distributions and the income going to your family, but having someone else operate it and run it on a daily, as a daily business. Or, maybe it's something where, you want to give your family the ability, the option, hey, you can either continue to operate this. If you do, we may want so-and-so to be involved in the daily operations. But if you don't, then you have the ability to sell it. And you have to make sure that you're giving them that authority to be able to sell it. And then who do they sell it to? Do you want to give a right of first refusal to any key employees? Give them the ability, longtime employees that may want to purchase the business and run with it? Or no, do you want to sell it to a third party, someone who's not involved in the business? all these types of questions can be addressed in the documents. And again, it just all goes back to a business is not the same type of asset as, just a general bank account or cash or securities that you can sort of leave to another person or to a trust for the benefit of another person. There's all of these other surrounding factors that you really need to think about when putting together the estate plan or when updating an estate plan.
Hey, Micah, let me ask you something. Just wondering what kind of the current trends are, because, more and more family businesses are, the kids don't necessarily want them. And oftentimes, like you just described, there's maybe one kid who's in the business, running it. So are you seeing situations where upon the business owner's death, they call for evaluation of the business, that asset goes to the child who's running the business, and the other kids receive other assets of equal value? Is that a feasible strategy, or is that I know a lot of times you probably have to have a lot of life insurance because the business might be the big asset, but I don't know. Do you see that working or not so much?
So it's a good question, Walter. We definitely see that a lot. And in some situations, it does work. In others, it really does not work. And then it becomes a question for the client. And I'll give you an example here. I just started working with a client, and they own a few LLCs, and some of them are owned just by the couple, 50% each. Others, maybe a brother is involved in with the couple. Another one, the son is involved in. And what they want to do is they want the business, the LLC that involves mom, dad, and the son, to go to the son when they pass away. He's going to be working in it. He's putting in that blood, sweat, and tears and everything. And they want him to see the upside and the appreciation and the benefit. So let's say right now that business is worth $5 million. They're saying, okay, well, we want our other two kids to receive equivalent amounts of money at that time. So give them all of the retirement money, give them all of the money in the brokerage account, whatever it may be. But then the question becomes, okay, what if this business is very successful? And when you pass away, it's worth $15 million. Now we only have, let's say, another $7 million to split between your other two kids.
Yeah.
Right? That becomes the problem. And once you start thinking about, there could be retirement money where the beneficiaries are a third. You need to change those because you need the other two kids to get a greater amount of the proceeds. It gets very complicated. So doing that, the question of do you want to try to equalize can be very difficult. And it's something that we need to walk through together and certainly involve you guys in the considerations too.
I mean, have you seen?
Micah, I think I have a bias, and when it comes to strategies, tell me about what you think of my bias, because I think what I'm about to say addresses the challenge that you just eloquently outlined there, and that is, if at all possible, have the kid or the kids in the business purchase the business from the parents. So then the balance of the assets can just very easily be distributed equitably or fairly, whichever word you want to use. What do you think about that? I mean, of course, it all gets down to what the client wants to do and what their motivations are and their values and all like that. But what do you think about that strategy as me being biased toward it? Would you sway me away from that bias or?
No, I certainly wouldn't sway you away. I think it's a great approach. I think it's a good solution. Obviously, there'll be some situations where it doesn't necessarily work, or it's not, appropriate for the client, or maybe they don't like that approach for whatever reason. But I do think it's a great way to handle that problem. When it comes to sort of buying it from the parents, because it can sort of offset the difference in equalization if the business is worth a lot. The only thing that we would really need to address, and it sort of involves looping the whole family in, is sort of what if the son, in this case, who is receiving the business, can't afford to buy it immediately. Then we sort of need to say, okay, well, over the next X years, you are going to be paying your sisters or your brothers, whoever it may be, or trusts for their benefit, this money in order to buy it from the rest of the family, right? And so it's important then that we have those documents in place, because we certainly don't want the kids to fight about it. We could say in the documents, yes, when I die, my son gets the business and he needs to buy it back. But we really should articulate and clarify, how is that going to be happening? Does the son have enough money to do this? If not, where is that money coming from? How are they going to get paid? Is it going to be monthly? Is it going to be annually? Things like that.
Mm-hmm. Yeah, it was a year or two ago that we had you on. We talked about the use of revocable trust, and for a sole owner, business owner, how oftentimes, and I guess this is a bias of mine as well, or a default where, and you know this because I'll always ask you when we refer a client to you, Micah, should they consider putting their business interest in a trust to smooth out, if you will, the business continuity issues, to avoid probate, so on and so forth. Why don't you we've done a whole podcast on that, and listeners, I'd encourage you to go back and listen to it. It was a year or two ago, but just give us a brief recap of what you think about that idea.
Yeah, so just real quick to bring everyone up to speed. So when you pass away in most states and you have a will, or even if you don't have a will, any assets that are in your name without a beneficiary go through what we call the probate process. And it's addressed by the courts or register of wills, depending on where you are. And basically, let's say over the next 9 months to a year, you file certain documents and the courts will approve certain things. You get everything appraised. And then at the end of the time, they say, okay, it's approved. You can now distribute out the assets. So that's the probate process. When we talk about setting up a trust and moving assets into it, the primary reason for doing that is often to avoid probate. So if I set up a trust for the benefit of myself and my wife, and then while we're alive, and then when I die, it stays in trust for my wife's benefit, and then when she dies, it goes into further trust for our kids, right? I would put other assets in there, bank accounts, brokerage accounts, our house, and basically anything that I retitle into that trust is still mine while I'm alive. I still have full control, but those assets avoid going through the probate process and getting tied up for, let's just say, 9 months to a year when I die. And it's much smoother transition. It goes right to my wife and then to my kids. So that's why lots of people set up revocable trusts. Now, when it comes to the business interests, okay, the reason for putting it into a trust is not only to avoid probate, which can be expensive and time consuming and a bit of a hassle, but it also solves the problem of, what if I become incapacitated? What if I pass away? Who's running the show here, right? Who's making the decisions? Who's making the decision to continue the business or to sell or liquidate the business, right? Who is stepping into my shoes and being able to do what I can do, what I do on a daily basis? When you have a trust and you put the business, your ownership interest into the trust, it's a very smooth transition to that person. You get to name who's that person going to be. If it's going to be people in your family, then maybe we can put it into a revocable trust that you've already set up, and we'll have, whoever you have named as your successor trustee take, just as they're going to administer your brokerage account and pay your bills and work with your CPA to file your tax returns, they can also run the business. But If it's not that person, which oftentimes it may not be, it may be going back to a key employee, a business partner, whoever it is, to run the business in your absence, we might want to put it into a different trust. It's still a revocable trust, but in this case, we call it more of a single purpose trust. And the single purpose is just to administer the business interests, say what happens, what authority they have, who's running the show, if you become incapacitated or pass away. Again, it could be the same people for all your other assets, but oftentimes it may be different people. So putting it into this trust, nothing changes while you're alive. You're still in complete control. You own it. You can sell the business. You can gift interest in it if you want. But if you become unable to continue, basically running it and operating it, even temporarily, it's a very smooth transition to the next person. You have control. You're articulating who that's going to be, and you can even spell out what their authority is, what you would want them to do, what considerations, who else they should speak to. Reach out to Pat, reach out to Walter, whatever it is that you want to include in that document. So the use of the trust in that example is really, really important. If you don't have that, you're relying on maybe possibly a power of attorney, which frankly is just not as accepted and not as easy, let's say, to transfer power, rather than when you're using a trust and you have everything spelled out in one document as to what you want to happen.
Hey, Micah, the current estate exemption is like 12.5 million or something. That ends in 2025 and goes back to about 6 million. Is that right?
Yeah, so it's scheduled to sunset January 1st of 2026, so at the end of 2025, and then it'll drop down to 5 million adjusted for inflation. We're thinking between 6 and 6.5 million. Yep.
Yeah.
Mm-hmm. Yeah, and talk a little bit to it. Let's talk. I think we've been mostly focusing on sole owners here. Let's take the last few minutes and just give some counsel for or reference partnerships or businesses that are owned by more than one owner. Where do you see, neglect in planning in regard to estate planning / coordination with other legal documents like buy-sell agreements?
Yeah, so it's a really good question, and it comes up a lot. And if you haven't planned in advance, it can become a major issue. Let's just take a situation where if I'm in a partnership with another person and we're operating a business, and I pass away, right? Let's say I own 50% in it. And let's say my will or my trust leaves all of my assets to my wife. Well, I pass away now, and my wife now owns 50% of this business. That partner that I had may not want to be in business with my wife. Maybe they wanted to be in business with Micah. We had, founded this company. We know the ins and outs of it. We were a great team, but now they have to work with someone who maybe they've never met before. Right? They may not want that. So we would want to have documents in place that address that in advance. Who can become an owner on incapacity or death or a sale? We want to address that in our documents. Now, do we want to give the other co-owner, the other partner, the ability to purchase my interests when I die and have the proceeds from that sale go to my wife, and then she can use the money, but she's no longer in business with this other partner, and the other partner can then run the show. They can bring more people in if they want to or not, but it's their business now, and we've sort of eliminated that potential partnership that no one maybe wanted. But oftentimes with that comes the question is, well, how are they going to buy those interests from my wife in that example? Where's the money coming from? Oftentimes, the business may not have enough liquid funds to just be able to purchase what could be a very valuable interest in this business. So we need to plan, well, where would that come from? Again, would it be done with a promissory note over several years? What if the business, for whatever reason, fails at that point? Then does my wife not get any money? So oftentimes we may look at life insurance, or what you reference as a buy-sell agreement. It may say, you know what, we're going to buy life insurance on Micah and his partner, and the business might own it. And so when Micah dies, the life insurance that gets paid out, the death benefits on my life to the company can then use that to purchase my business interests. And now everyone wins, right? We have, other than hopefully my wife being upset that I've passed away, we have the proceeds ultimately going to her. So she's got the value, the money for that. And then the business and the ability to continue operating it and have control over it to the co-partner. So, it's things like that you really need to focus on in advance. If not, you run into all of these issues as to what happens to the interest. What if you don't want to be in business with someone? What if you want to buy it, but you can't afford it? All of these things.
Fantastic. And listeners, if you want to, we did a podcast, Walter and I did a podcast just on buy-sell agreements within, I think, the last 6 months to a year. You can look back and find that too. But we're going to close here in a second. Thank you again, Micah, for all this time. Do you, well, here, let me ask you this. Any last thoughts or wisdom that you would share with us before Walter closes us up here in a second or two?
I think the biggest thing overall is oftentimes, all of us can huddle up and get together and resolve problems, right? We sort of had that confidence, we had that experience. The key is addressing it, realizing it, and addressing it in advance. So you may think that you want to sell your business in 2 to 5 years. Now is the time to start meeting with Pat and Walter, people like myself, to really coordinate everything, make sure the plan is going to just, if you wait till the last minute, or if you don't get a chance to do it in advance, that's where it gets really messy and expensive. So the best advice that I can always give is, reach out to people like Pat, Walter, myself in advance.
Good. Thanks, Micah. Good advice.
Hey, Micah, how can listeners get in contact with you?
Yeah, thanks, Walter. They can reach out to me. I'm at Stein Sperling in Rockville. My email address is mbonaviri@Stein Sperling. You can get that on the website as well. And then my direct line for anyone that's interested in calling is 301-838-3235.
Fantastic. Thanks again. This has been, as always, very, very helpful, very useful information. So thank you very much for joining us.
Thank you, guys.
And listeners, if you want help in planning your business continuity, please get in touch with us today at exitreadiness.com or email at exitreadiness.com. And if you use the code podcast when setting up a free exitreadiness.com account, you'll receive a 10% discount on any products purchased. That rivals whatever Amazon is doing right now.
That's right. That's right.
It's unbelievable.
That's right.
So until next time on the Exit Readiness podcast, this is Walter Dial and Pat Ennis signing off.